Thank you, Your Honor. Our response to the defendant's motion for summary judgment is the exact same response every single plaintiff's attorney has ever had to a motion for summary judgment when they have confidently stood before the court and said, it's a jury question. Now, given the venue, we would probably take it's a jury question and translate it into it's a question of fact to be decided by the finder of fact. But that doesn't quite have the same succinct ring as it's a jury question, so I'll just stick with that. It's the same rationale that pushes most cases in Pennsylvania past the MSJ. The standard is very low. Once we set forth evidence establishes the fact of the case goes to the jury. Obviously, in medical cases, one of the most common sorts of evidence is expert reports. The expert reports themselves satisfy case elements, and they are evidence. And that's really the grave man of this motion for summary judgment. It's the report, which was authored by the plaintiff's expert on liability and causation. The motion for summary judgment doesn't acknowledge the report, and it presents an application for summary judgment as if the report doesn't exist. The problem is that the MSJ makes these blanket assertions, such as there is no evidence that would support the contention that the intent of this form is for the transferring of service to the provider when receiving at the facility. But when this statement is put right next to our expert report, we see the evidence shows that the resident transfer form is used to communicate pertinent information. The expert goes on to discuss the standard of care and the very purpose of the rules. Here, I'll rearrange this slide and clear it up a bit for you. And when you see these two claims bluntly put one next to the other, there is only one conclusion that can be drawn. Sides claim that there is no evidence on this point is false. I'll give you another example of this, and I won't go through the whole drawing of the slide. I'll jump straight to the screenshots that come from the documents. Side claims plaintiff has failed to produce any evidence which would demonstrate any inactions on the part of the defendant that caused the plaintiff to fall. But the truth is, our expert explicitly established three things that the defendants and its employees failed to do. There they are, plain as day. That is evidence at this stage of the case. So once again, claim that the plaintiff has failed to produce evidence on this point is simply false. Now, I'm not going to go through this exercise point by point, but suffice to say, this application contains numerous boilerplate allegations that are similarly false when they are held up against the expert report. Okay, so that brings us to the question at the MSJ. Are there any genuine issues of material fact? I'm not going to go through them here because they are painstakingly detailed in the motion papers, but multiple genuine issues of material fact are detailed. I know that it's a bit of a shtick to present it quite like this, but if we clean it all up, we realize that there's nothing cute about all of the disputes that are left in the case at this point. There is all of these material issues of fact, 6 of them if we count it. Your Honor, this case is so far from being subject to summary judgment. But I've saved the best slide for last. It's powerful because it comes straight from the Supreme Court of Pennsylvania. As if the justices there were writing for this case. They said, At the summary judgment stage, a trial court is required to take all facts of record and all reasonable inferences therefrom in a light most favorable to the non-moving party. This clearly includes all expert testimony and reports submitted by the non-moving party or provided during discovery. And so long as the conclusions contained within those reports are sufficiently supported, the trial judge cannot, sua sponte, assail them in an order and opinion granting summary judgment. Contrarily, the trial judge must defer to these conclusions, and should these conclusions be disputed, resolution of that dispute must be left to the trier of fact. It gets me right back to the place where we started from. It's a jury question. The motion for summary judgment must be